Hi everybody, it's Ajanette and I am here for your final lecture. Woohoo! We made it through. So we're covering contemporary issues, which we're going to go into kind of some specialty areas that some of you might actually be interested in. So first we're going to talk a little bit about forensic psychology. And so forensic psychology is a very broad field in and of itself. It's a specialty area within the field of psychology, but really anything that has to do with the law and psychology combined, that is forensic psychology. Now, a lot of people have a misconception that forensic psychology is, like what they see on Criminal Minds, and that might be one aspect, right? But it is actually much broader than that. It can include custody issues. It can include competency issues, whether that's criminal cases, whether that's somebody looking to take conservatorship over their aging parent, or somebody struggling with mental health issues. It can be any kind of screening or assessment for any legal matter or issue. It could also mean helping with jury selection and things of that nature. So it's a very, very broad field. And then, like most fields, like clinical psych, you can specialize within that field. But actually, individuals who maintain kind of a broader scope might have greater opportunity to have an independent practice that serves forensic psychology needs. But typically you find people specializing in kind of family law or criminal law, but rarely both. That being said, I do want you to understand that it can involve anything related to legal issues requiring assessment of mental health, treatment for mental illness, and or evaluating someone in terms of competency or other related matters. We are relying on our knowledge base from other areas of psychology, including clinical psych, cognitive psych, particularly as it relates to like a conservatorship hearing, social psych too, particularly as it relates to maybe jury selection, understanding human bias. So forensic psychology will be one of those intersectional fields that relies on research from other specialty areas. And as I mentioned, clinical psych is probably the most prominent, where you need to be able to do clinical assessments of individuals. So here's a list of different things that a forensic psychologist might encounter and might need to do. Let's talk about different commitment issues. And when we're talking about commitment here, we're talking about committing someone to a mental health institution. Someone can commit themselves, right? Like I can sign myself in, and that's what we call a voluntary commitment. But you can also commit someone if, in fact, they're a threat to themselves or others. And so that's what we would consider an involuntary commitment. And this stems from the government's right and duty to really protect an individual, even from themselves, or also their responsibility to protect others if that individual happens to be a threat. And so a civil commitment historically in our country has been weaponized sometimes. It's been weaponized with racial bias. It's been weaponized with gender bias. At one point in time, a husband could commit a wife just because. And unfortunately, there's been a history of not really honoring and respecting the rights of these individuals. And so consequently, patients' rights have evolved. Advocacy groups have evolved. NAMI is a wonderful source of information for that. But know that the criteria that we use to establish commitment, legal authority to commit someone, it can vary from state to state. In California, I have been engaged in commitment processes with my own family members, and the individual, they have to meet a threshold of danger, right? they're either a threat to themselves or they're a threat to others. That can be visible to people where they're neglecting their health and well-being, their physical appearance. They're unable to take care of themselves. And so when we think about, can someone really, are they in their right mind where they can take the steps necessary? So sometimes my dad, who is bipolar, went off of his medication, and he was not able to make reasonable choices about his medication. He was unable to monitor his medication. And so in those instances, it became necessary to intervene, commit him, get him stabilized. And once he was stabilized and released, he could manage his medication and his mental health. And during those times, he probably wasn't the safest individual to be around. So if an individual thinks that someone's about to lose control, they require mental health intervention, that is when maybe they need to be researching a commitment as an option. So in terms of, how do we meet that threshold of danger? Again, it can be self-harm or it can be a danger to others. But it's interesting how we kind of stigmatize mental illness overall, and we assume anyone with mental illness is a danger. And that's not really a reality. And that actually perpetuates the stigma surrounding mental illness. Individuals with mental illness are actually more likely to be harmed by the public than they are a threat to the public. And the challenge is we often misconstrue violence with mental illness, and we assume someone who is violent has to be mentally ill, and that's just not the case. Some of this is perpetuated by media, particularly as it relates to like mass shootings or other high-profile events. We often instantly go to the mental health or mental illness of that individual. So gun violence is often a topic that is misconstrued with mental illness. And some people, I had a friend, because I tend to believe the best about people, and I had a friend who's a sociologist, and she said, Ash, sometimes people are they're just assholes, they're just evil, and you have to accept that. And I was like, okay. It was a process, and it was related to a different matter, but there's a lot of wisdom in that statement, right? Where we don't always have to justify an action. Sometimes people are violent, and mental illness is not, in fact, a factor. They may just be violent or aggressive, or have a worldview or experience that might account for that violence without them being mentally ill. They can be of sound mind. It may be a mind that I don't agree with or you don't agree with, but it is of sound mind. So it's really important to note that most people who have mental illness are not dangerous, particularly when they're in treatment, right? Like my dad could be dangerous, but that's because he had hallucinations and delusions when he was in manic episodes. Otherwise, my dad was not really a dangerous individual. Most individuals who might present a danger, the danger is more likely to themselves than to others. So we need to make sure that we're breaking down that misconception and we're countering that stigma associated with mental illness. In reality, only about 4% of criminal violence is associated with mental illness. And so we have to recognize that individuals who suffer from mental illness are more likely to be targets. In fact, 3 times more likely than they are than the general public. So when we're talking about that threshold of danger, we're talking about someone is literally going to be harmed physically. And you might have someone that has a past history with law enforcement, and you definitely have to consider in context, because they might be, dangerous in one context per se, but not overall. And so we want to be mindful of that. And I take into consideration, I worked with sex offenders for about a year, and sex offenders in general, the ones that I worked with weren't a danger, but maybe in an environment where they were exposed to, let's say, if they were child sex offenders, being around children is problematic, right? So you have to take into consideration those things. In terms of civil commitment, as I mentioned, it can vary from state to state. In the state of California, you can be held for a 72-hour hold. Law enforcement can get involved. That's what we call a 5150. It's a psychiatric hold. They take you in because you're a threat to yourself or others. After the 72-hour hold, the doctors have the right to say you are a continued threat to yourself or others, and they can extend that to a 14-day hold. At the 14-day mark, you're entitled to a hearing. That hearing can be requested. It's going to be automatic, but you can have a family member, a friend there to advocate for you. You can have legal representation, but ultimately a mental health practitioner too often are required to indicate that they feel that you are a continued threat, and that is necessary in the state of California to continue to hold you. But after that 14-day hearing, you are entitled to regular ongoing hearings. In general, across the nation, the average confinement for civil commitment is about 6 to 12 months. Unfortunately, we have a mental health system that is highly impacted. So it's quite often that people are let go after 72 hours. And they may not have the adequate tools to remain stable. So you have to watch out for individuals that are taken in for 5150 repeatedly, often because they're a threat to themselves. Because those individuals who have recurring suicide attempts, they are at greater risk of actually committing suicide and completing suicide. And so we want to be mindful of that. If there is any kind of imminent threat, hearings can be requested sooner. And it's really important that we're not violating their civil rights. So the Supreme Court says there has to be clear and convincing proof, which is defined as 75% certainty that you are a threat. So I don't have to believe 100%. I can have that reasonable assumption, and that's been quantified by the Supreme Court. Let's talk about criminal commitment. This is a little bit different, and although this is kind of sensationalized in the media, it's rarely actually done. We have Patton State Hospital here in San Bernardino County that is used for criminal commitment, and so those individuals have been or are being accused of crimes, but unfortunately they're not either mentally fit to stand trial, or their verdict or outcome has been associated with their mental illness. And so instead of being sent to jail, they're sent to a mental health institution. And I want you to be mindful that not all individuals who are incarcerated have mental illness, and those that do are not always committed. It's not uncommon that individuals who are incarcerated are actually receiving mental health care. I have a friend who is a psychiatrist within the California correction system, and he regularly sees patients who are incarcerated, and they have a range of conditions and disorders for which he treats them. And I'm thankful because he brings with him a tremendous amount of empathy and compassion to that care. So just because someone is incarcerated doesn't necessarily mean they should be treated inhumanely, right? And it doesn't mean they should have their rights violated. And our judicial system is not perfect. So there very much could be biases, or there are, that's been established in the research. There are biases. There's racial biases, there's gender biases, there's wealth biases. We find that individuals who come from poverty backgrounds or low-income backgrounds and can't afford those expensive attorneys have much higher conviction rates than those who have very expensive attorneys. And so we need to be mindful of that too. Because our judicial system has biases, not everybody who is incarcerated is necessarily guilty, right? And so I'm really thankful for my friend who takes the time to get to know his clients and gives them maybe support for the first time in their lives. Because one of the most common predictors, or most common shared traits of individuals who are incarcerated is instability in their family environment. And many have been abused in their childhood. And that trauma can definitely lead to different choices and outcomes in one's life. So, in terms of the insanity plea, this is when somebody pleads not guilty by reason of insanity. And so they're acknowledging that they did commit the crime, but they're also at the same time stating that at the time of the crime, at the time the crime was committed, they weren't of sound mind. And so that allows them some leniency per se. And we can have short-term mental health breaks, right? We can disassociate, as we've learned. Often trauma contributes to that disassociation. And we may engage in behavior that we would not normally or otherwise behave in or engage in. So the history of the insanity plea stems back to Daniel Mcnaughton from 1983. I'm actually going to link you to a resource that takes you through some of the history. But he actually murdered the Prime Minister of England, and he had these delusions of persecution. And his case actually contributed to the Mcnaughton Rule, which is a criteria used by some states to determine whether or not an individual can plead not guilty by reason of insanity. So different states use different criteria for what constitutes insanity. And if you click on this image here, it'll take you to the history of the Mcnaughton case. But it's important to note that the Mcnaughton Rule says that you aren't automatically insane, right, just because you have a mental illness. So an individual can be mentally ill, but that does not mean they're insane. They're two different things. We use the word insane kind of loosely, but in reality, it's a legal term. Mentally ill is a health term. Insane is a legal term. Not everyone who is mentally ill, which, they meet a diagnostic criteria in the DSM or ICD-9, or not 9, it's I think 12 now, but in the ICD, or not everyone who meets this criteria for insanity. So it's important to understand that. But the Mcnaughton Rule says that an individual, in order to be legally insane, they do not know right from wrong at the time that the crime was committed. Then there's alternatives, right? These two other alternatives or criteria that may be used in other courts. The Irresistible Impulse Test suggests that the person is not able to control or resist the impulse to engage in that behavior. And so a therapist would be involved, and they would do an assessment and determine whether or not that person has full control over their behavior full control over the behavior that they engaged in and for which they're being prosecuted. Durham test is sometimes known as the products test, and that is kind of a lower threshold where it actually states that you're not responsible for the crime if it's due to your mental illness or a mental defect. So let's say, like Law and Order, there was a case where an individual had cognitive impairment, and so they had poor intellectual capacity. Even though they were a grown individual, they had the mental capacity of a child, and they were influenced by these young girls to engage in illegal behavior. And so, but that individual was not necessarily they didn't have the mental capacity to make good choices. And so that, even though they weren't mentally ill per se, they had cognitive impairment, and that would classify as a mental defect. So the Durham test is more flexible, but it's certainly a little vague and ambiguous, and again, not all courts use that. So when you're talking about a criminal commitment, this is when someone is actually going to be committed through the legal system, and this is the criminal justice system. So it's not through like a probate court or a family court that's assessing conservatorship. It's actually done through a criminal court. And the American Law Institute standard from 1962 is actually an alternative to the other criteria that we just talked about, but it says they're not responsible for their actions if they had a mental disorder or defect that prevented them from understanding right from wrong. And so this was the standard used for many years, but it's very controversial, right? I was watching a movie with Matthew McConaughey, Samuel L. Jackson, his, I want to say 9-year-old, it could have been 11-year-old daughter, was raped by these two gentlemen. It became a high-profile racial case, and these white, I shouldn't call them gentlemen, these white individuals raped and really maimed this little girl, and the father murdered them. And what's interesting is, like, is he really mentally ill? No. But in that moment, could he distinguish between right and wrong? No, he couldn't. And what's really interesting is society as a whole, would we consider it wrong, in that situation, particularly if it was our child? So just something to think about, where these issues aren't black and white, right? There's no easy answer. And so therefore it's important to kind of consider the context and the facts of each case. The Federal Insanity Defense Reform Act was passed in 1984, and it is more comprehensive legislation that helps to kind of provide a little bit more clarity and structure. And so it actually, unfortunately, I don't know that this is the best thing, but what it did is it shifted the burden from the state to the defendant, where the defendant actually has to provide clear and convincing evidence that they, in fact, were insane at the time of the commission. This limits there, right? So when you talk about an insanity plea, they're rare. They are most commonly, not only are they rare, they are rarely successful. They are most commonly successful for white defendants. They are most commonly successful for wealthy defendants. So those are all things to think about. You really need to have someone that specializes, an attorney that specializes in understanding the criteria and the laws associated with it. But in general, it's really important to understand that it doesn't mean you're off the hook. It means now you have to have a separate hearing, and they look at committing you into a mental institution so you can receive appropriate treatment so you are not a threat to others. and now the doctors have some influence and control over your destiny. It is not a freedom automatically. So if you are found to meet the criteria for insanity, then it does not necessarily mean a get out of jail free card. Oh, and one more thing. Not all states allow insanity pleas altogether. So that's something to think about. There are alternatives. So you can be found guilty of a crime but mentally ill, which effectively is kind of the same thing. But it gives a juror the kind of flexibility to to convict. But they, instead of sending you to jail, they might send you or recommend treatment. Then there's also another assessment that sometimes has to be done, where a judge may want to assess whether you're competent to stand trial. In the United States, we have our civil rights and protections under the Constitution. And one of those is we have a right to a trial, right? We have a right to legal representation. But we need to be able to actively participate in our defense. That means we have to be able to work with our lawyers. We have to be of sound mind. We have to be able to give them the facts that they need. We have to be able to understand what's happening around us. We have to be able to actively support and participate in providing the court and our attorney the information needed to put forth our case and our defense. And not all individuals are of sound mind to go through that process. And so instead, first of all, if there's questions, then the judge can order an assessment to be done. And this is, again, where forensic psychologists might come in or psychiatrists might come in and assess competency. And they can also, if they determine that you're incompetent, then they can recommend that you be institutionalized or you be committed. And again, this is where you would be sent to some place like Patton. It's not in any mental institution. It's a mental institution that is under the control of the judicial system or corrections. So trial likely would be postponed until you have been assessed properly. Okay, so I want to talk a little bit about another kind of legal issue, and that's patients' rights. So it's really important to know that if you've ever taken an abnormal psych class, or sometimes in intro psych classes, if you ever get into psychotherapy classes, we have a very sad history in this country and how we've treated individuals who suffer from mental illness. And unfortunately, there was a time when they could be locked away forever and often treated in very inhumane conditions. And so there have been various case law cases that have been done that establishes case law. So law is established two ways. It's established by a law that is passed by a legislature, or it's established through case law. So rulings from other cases, and this is what you often see in a courtroom, where lawyers are arguing other cases that have had similar fact patterns in order to sway the judge and suggest that they should rule a certain way. And so Roos versus Cameron actually said that individuals have a right to treatment, and so that is their constitutional right, and it's important that they be granted proper resources in order to get treatment. Additionally, the state, based on Wyatt versus Stickney, the state is obligated to make sure that people who are in fact institutionalized get appropriate treatment. They're not just left there, right? But they have access to therapy, to privacy, to exercise, to social interactions. So they need to be given humane living conditions. Additionally, O'Connor versus Donaldson said that they have to be reviewed periodically. You can't just lock them away and it's indefinite. They need to have ongoing hearings or assessments to see if at some point they reach a point where they are stable and healthy and they can be released. So if they're not a danger, if they can survive on their own or with a support system, then they are entitled to be released legally. Not only do they have a right to treatment, patients also have a right to refuse treatment. And this is Riggins versus Nevada. They do not have to consent to treatment. So we cannot willfully impose treatment that they do not want, including medication. That's why often, like in my dad's case, if he didn't go on his meds, sometimes a hearing has to be held where the judge says, yes, they have a right to put him back on his medication. And so that unfortunately was a process we had to go through a couple of times. They also have the right to less restrictive treatment, so they don't have to be, in many cases, like they don't have to be restrained. They can be in mental facilities that allow for a more community environment. And so Dixon versus Weinberger established those rights. Hospital commitment should not be necessarily the norm. Now, the challenge is there may not be adequate facilities available in any given region. There aren't, and we are an impacted field. So even though legally and ideally they would all receive healthy, supportive treatment, that's not what we often see. And so it can be a very heart-wrenching process to see a loved one in a facility. They also have the right to live in a community. So it could be an adult treatment facility as opposed to, again, being institutionalized. So you can click on this this image and it will lead you to NAMI's information about patient rights. And so the final legal issue that we're going to talk about is the legal obligations of the therapist. So it's really important to recognize that you have a legal responsibility to your clients if you choose to go into therapy. That is whether you're becoming a psychologist, a marriage and family therapist, a licensed clinical social worker, a PsyD, or a psychiatrist, right? That what that patient shares with you needs to remain confidential. There are two circumstances where you would break confidentiality. That's if they're a threat to themselves or if they're a threat to others. And so it's really, really important that we recognize that. Even, in terms of them committing a crime, that information that they have shared, if they've shared that they committed a past crime, that's confidential between them and their therapist. And a therapist can actually lose their license for divulging information. So it's very serious. Additionally, that communication between a therapist and a client is privileged. So the patient has to give permission, but it is legally protected. And in a court of law, a defense attorney would actually describe it as privileged communication. Now, there are exceptions if an individual is under 16. In the state of California, when the individual becomes 12, they actually have a legal right to consent to their medical records being released or not. If the individual is an elderly individual, but they're dependent upon others, such as a conservator, then the conservator then bears that right to waive privilege or to to waive confidentiality. If they are the victim of a crime, then the state has the right to use that information for the purpose of prosecuting that crime. And again, if they're a danger to themselves or others. And then finally, the therapist has a legal duty to warn. So if in fact, and this comes from Tarasoff versus the Board of Regents through the UC system, if in fact they are a threat to someone else, if there's any kind of danger to a member of the public, the therapist has a legal obligation to warn that victim. So if you had an individual come in and threaten to commit a crime or to hurt or harm a particular individual, you have a duty and an obligation to warn that individual that they could potentially be in danger. And so that's really important to recognize. So I just want to share, give me just a second while I look it up. Forensic psychology is an increasingly popular major. And so hopefully you have a broader understanding of it now. I do want to share with you, UCI has a legal and forensic psychology major it's a master's level program, just so you know. You would make sure if you're doing a bachelor's degree that you take lots of classes and take abnormal psychotherapy classes, things of that nature, where you're getting the clinical aspect. And then it would be important to get research experience too, because when you're applying to grad school, that makes you more competitive. So UCI and CSULA has a Master of Science in Forensic Psychology. So I just wanted to throw that out there for those of you that might be considering forensic psychology as a career option and what your degree in psychology can potentially lead to. There's also mediators in the family law court system. So they usually will do a clinical, either a licensed clinical social worker, or they will become a marriage and family therapist, but they will go on and become licensed, and then they actually will do mediation, and they often will testify in courts with regard to custody issues. And so those are also an option. They still fall under the umbrella of forensic psychology, but they also intersect with clinical psych. So just throwing that out there for you all. Hopefully it's helpful, and it's been wonderful teaching you over this semester. I really want you to understand when we're talking about abnormal psychology or clinical psychology that we need to approach it with a heart of compassion and empathy. For those of us who have had loved ones who suffer from mental illness, or maybe ourselves, we have suffered from various mental health conditions. I want you to recognize that, it's more common than you realize. That's why I don't like the term normal and abnormal, right? Because when you say, oh, I'm normal, I just had this conversation with my son today who actually suffers from anxiety, and he was describing himself as abnormal, and I absolutely refuse to subscribe to that language. He's very much normal, and all of us know what it's like to experience anxiety. All of us know what it's like to experience depression. Not all of us meet a diagnostic threshold. Not all of us actually suffer from major depressive disorder or generalized anxiety disorder, but we can all relate to those moments in our lives where we have felt those emotions. And so I'm going to encourage you, moving forward with the knowledge that you've gained in this class, to be part of raising awareness, be part of destigmatizing mental illness, actively talking about mental illness, recognizing that the factors that contribute to it are just as much biological as the factors that contribute to diabetes or other health conditions. And so it's really important that we don't look at someone as having flawed character or as being weak or expecting someone to just get over it. It's a medical condition. It warrants the same kind of empathy and compassion as my cancer warranted. So I do hope you will all continue to learn and grow and join myself and my colleagues in raising awareness and advocating for individuals and their families. Thanks so much. Enjoy.